Okay, I think we'll start our class while waiting for the rest to join. I think should be okay because first two slides is not so important. Today I'm going to talk about this criminal procedure code. Okay, I'm gonna talk about this police investigation, but first and foremost, let me just make some disclaimers. I'm just a very junior lawyer, and I do not guarantee this teaching may guarantee the quality and, of course, the accuracy of the information. I also do not provide any guarantee or warranty of any sort. And this lecture itself is just a guide for you, a very general and very superficial guide for all of you, and it should not be considered as academic reference. Okay, okay, I'm going to go through with you today the police investigations. So, which are the important sections that assist the police in order to execute their jobs well are actually being laid down in your section 107 up to 114. As you all may be now familiarize yourself with this CPC code, criminal procedure code, it is very, very important for all of you. Okay, you must at least know where to find your answer. If you are not familiarized with the whole section itself, it's still considered okay. But you have to know what is the title of this particular section, especially this sort of important chapter. For example, in regards to your 107, section 107, it is about your first information report. Your section 107A is the inquiry of the status of investigation from the complainant to the police. Okay, and you have your section 108, okay, and section 108A, that is emission of CTC copy lah, of this FIR, as well as there are procedures that govern uh, the police, whereby this is provided under your section 108 as well as section 109. You can seek a distinction in between how the police will treat if it is a seizable offense or it is a non-seizable offense. We'll discuss it later. And section 111 up to 114 will be sort of like rakaman percakapan as required by the police towards the witness to help and assist the police in due course of their investigation. Okay, 114 is the police shall not prohibit or stopping anyone from making any this police report lah. Okay, because they think this is not important, then they refuse on taking the report. This cannot lah. Okay, this is provided under section 114. So again, please be reminded, you must be familiarized with at least the heading of this CPC. Okay. So what is actually a first information report? In a very layman term, if we are talking about police investigation per se, usually first information report itself is a police report, report police. Okay, and there are important section that is governing the ruling. How should be the format of this FIR itself, and how should it be converted in this form? Okay, so if you look at your section 107 sub rule 1, it is clearly stated that the FIR itself, okay, must be reduced into writing. The word is shall. Shall means compulsory, mandatory. Okay. And it should be done by a police officer in an oral form, whereby a police officer in charge nowadays is typing the computer. Okay. After that, taking the said information from the complainant, for example, the police officer has the duty to read back the police report, the contents of this police report to the complainant, and then ask them to sign. Okay. And your section 2, okay, subsection 2, provided that it shall be entered into a book lah. Nowadays, I don't see any book, but it is more on a computerized, central-based data. Okay, every police station can have access towards the police report made. For example, I'm now staying in Mua. Somebody lodged a complaint against me lah, for suspicions of uh, criminal breach of trust, take for example. So JB1 will know, So whenever I go to Setia Tropica, take for example, to my HQ, probably the police officer there will get the same information and investigate on the issue. Okay. And your subsection 3 is that even if, let's say, the said information is being provided by a person not inside a police station, this subsection 3 said that it shall be deemed to be received at police station. Meaning to say, if a police complainant talk to a police during rondaan, during the round or whatsoever lah, rondaan police lah, and then suddenly the police detect a crime, is a sudden onset of crime. Take for example, is a robbery. Okay, so the complainant says something to them, but subsequently the police type a report and ask them to sign. No doubt it is taken outside the police station, but it shall be presumed it is taken inside the police station. So this is one of the rules governing the presumption lah. Okay, and the police officer receiving such information shall record the name and address of the complainant or the informant, and also note down the date and time at the receipt of such information. Very important. I will give you one example of this report so that you can appreciate this section much better. And it shall be signed by the person who gave the information. All right. And one more time, it is emphasized here because sometimes we have a jurisdiction. You see, take for example, again, I'm revealing to you where I'm staying now. I'm in Mua. Take for example, I committed a crimes in Mua, but somehow or other I run to JB. So if let's say, for example, now I'm in JB, by right, the person that should come and catch me will be the IPD Johor Bahru, isn't it? But then I lodged a police report here. Mua police station, the complainant lodged a police report here. The police in Mua cannot say that because the accused already run to JB, so I'm not duty bound take this information, because once you receive information, the police must do something. Okay, they must do something. Uh, Taking into account this is a serious crime per se lah, they must do something. Okay, so there were some issues in the past that police say, "Ayo, this is not under my territorial jurisdiction. You pergilah JB, buat report sana, tak payah susahkan saya." Nowadays cannot, okay? They have to receive the information. Okay. Okay, I'll give you one sample of this police report for you to understand section 107 better, because last time I also had a hard time to memorize all this apa nama, the specific section, because it is very down provision. It's all words what you cannot imagine. So what I'm trying to do with this lecture is I make it more, how to say, infographic, so you can appreciate the section better. Okay, so from this police report itself, you can actually derive first information. It is in writing, correct? Because it is black and white what? Okay, writing, so it is in writing. Second thing, you can see the complainant or the informant, we usually call that pengadu is a complainant. Okay, the one that complain shall sign the thing. Okay, and then this is the officer, the police officer that type the report. Okay, and if there's a need to call jurubahasa, usually we do not have a so-called certified interpreter in police station. Usually the relative of the complainant shall explain and like just like intermediary to the police to translate the language, okay, to the police officer. And then you will have the details of this pengadu, okay? The name is there, the what we call the sometimes occupation is there, and the address shall be there, okay? Something like that. So you can see the provision of this section 107 is actually well fulfilled in this FIR. As simple as that, not so hard. Okay. So actually, what is FIR? Nowadays, we do not have too much dispute on the legal status of FIR because we have a lot of established case law to say that FIR itself is what we call is something that um, the police use to commence or initiate an investigation. But of course, this is not compulsory. That means to say, yes, because police itself is not God, isn't it? Police, they also depends on the information provided by the complainant in order for them to see whether there is a suspected criminal activities ongoing or not, or had been committed or not. So they have to depends on this information to get the ball rolling. Okay, but anyhow, this is not so-called precondition. This is not something to do with you must have a FIR, then police can initiate a motion in criminal investigation. But somehow or other, it is commonly so the case. Okay, and you can see this in this emperor against Khwaja Nazir case, very famous case, Indian case, and whereby it is saying that FIR itself is not compulsory for you to the police investigation. So having said so, police can depend on other sources like their intelligence report, which is confidential, can never reveal to public lah. Okay, or could depends on their so-called you see, for example, they do not need uh let's say they are doing rondaan and you are being caught for drunk driving, driving under alcohol influence. So they do not need a person to complain that, oh, my car, this one, JTF 136, for example. Okay, this person, this driver is actually driving under alcohol influence. They do not need, all they need to do is to do a roadblock, then they can investigate who is drunk driving. They have the right to do so. Okay, not too hard actually. Okay, so FIR, second thing is it is a public document. Okay, public document means it shall be accessible by public lah. This is under one of your Evidence Act punya issue, whereby sometimes you do not even need to call the so-called the maker to the court to testify the authenticity of this police report at all. Okay, and who can lodge a FIR? Anyone. Okay, not just merely the eyewitness of what we call the incident itself. Take for example, nowadays we have seen a lot of juvenile sexual kanak-kanak, the JSK cases, whereby the teachers, the counselors in the school, if they suspect one of their students are being perpetrated by the stepfathers, for example, they can actually lodge police report in police station to activate the investigation. Okay, you must know that lah. So anyone, not just the victim, not just the eyewitness of the crime itself can lodge. Anyone has the information, know the information, can actually lodge the police report, provided they are not falsifying the information. Okay, they are not lodging any false report. Okay, so eventually there's one good dispute here. For example, if let's say a person make a police report, but subsequently this police report is actually so-called premeditated. It's one of his strategies, to prevent the suspicions from the police. Take, for example, I have killed my wife. So I acted as such a way that I'm the first eyewitness that came to the crime scene. And then I called police, and then subsequently I lodged a police report saying that, oh, I found my wife, lying in the house bleeding. And then when I reached the house, she was not breathing and the heart is not beating anymore, something like that. So I lodged a police report. That doesn't mean that I could not be charged later on for the sake that I have made the FIR. Okay, so it all depends on the investigation, whether I kill my wife or not. Okay, so you must know the case lah. Datuk Sri Anwar Ibrahim, or else every so-called the suspect, because criminal minds, they are quite clever, and some of them will pretend um to lodge a police report, but as a matter of fact, they are the uh, real offender. Okay, so FIR again, this is just one piece of evidence, but this is not some sort of evidence that carry a lot of probative value or merits. It is just a corroborative evidence, just a supportive evidence. Very important, because you cannot treat everybody just come to police station and lodge a report, and you have to treat this the evidence with great weight. It's not like that. It is just something to corroborate the statement later on. For example, a witness see she's an eyewitness of the murder, for example. She made a police report. So this police report itself is just a supportive evidence for the coming trial. So the eyewitness is still material witness, whereby she shall be called to give evidence in the court later on. You cannot depend on this. Oh, you see, this eyewitness already give FIR, already signed this police report. Therefore, I don't want to call this eyewitness to testify against me murdering my wife. Take for example, cannot do like that. Okay, because FIR, anyhow, it is just a supportive evidence. Okay. And FIR is to facilitate further investigation. This one I already said to you many times. You can memorize a few cases. The first one is, of course, the Emperor against Khwaja Nazir. And the second case, probably you can take note, is Balachandran case. Okay, very famous case. Okay, last time, if you have a written one, but this one is no longer lah. Take for example, if the FIR does not contain the accused name, okay, this is just a very general FIR. Again, I'm using the case of my wife murder. So when the eyewitness, the so-called the informant or the complainant lodged a FIR in the police station, what he did was he did not actually saw me present at the scene. So my name is not inside the police report. So it doesn't mean the testimony of the complainant itself will be lower. That means to say, even though you did not see the person, but subsequently, that you did not name myself in the FIR, but you think that I am there, or you saw me leaving, but you missed this information out inside your FIR, it's still okay. Your testimony is more important. That means during trial, whatever you have given under oath, di bawah sumpah lah, that one is more important as compared to your FIR. That means to say, even though you do not mention, because that time probably the eyewitness is in panic state or whatsoever, he missed out the information. Okay, so this is acceptable by the court. Okay. All right, but somehow or other you can challenge lah. You can challenge when the informants fail to include this sort of very important details, but subsequently he said it later, then you can challenge his credibility. Okay. So this is actually the double-sided sword lah. Okay. And so I already told you FIR is just a corroborative evidence. It's not a substantive evidence. Okay. So, okay, again, delay in lodging FIR. Okay, this one often we see in crimes involving family members, or this sexual offense against children. Okay, the SOCAL. Because things will be, usually the scenario is very simple. Okay, the kids are staying with stepfathers. It is until they reach 18 years old, they can leave the family and move outside. Okay, but somehow or other they feel they were the sexual victims before by the stepfather, take for example. So they lodge a police report years after that, usually maybe we're looking at, if juvenile sexual kanak-kanak, uh, you know, probably that time they are just 15 years old, but then they lodge a police report when they are 19 years old. Such a delay will, of course make the credibility of the complainant to be lower. But subsequently, you cannot say that this is an absolute criteria. That means to say, if you do not lodge a complaint in a timely manner, it is still okay. It is still okay. Okay. But of course, the other defense counsel will never say so. I mean, the lawyers that defend the accused will probably go and challenge your credibility. Okay. But there are case law that say that mere delay in filing of FIR is no ground to doubt the case of prosecution. Okay, for the evidence given by the victim to be rejected. That means to say the complaint, however delayed, it is still probably acceptable by the court. And this is PP against Muhammad Terang bin Amit here. Okay, so we talk about the first reasonable opportunity rule. Even if it is not so, the court will consider what are the reasons. Definitely the court will take into considerations what are the circumstances that actually inhibit or stopping the complainant to lodge an immediate police report. Is his or her safety issue is at concern, or he cannot escape from the the control of the perpetrator. Take for example. Okay. Okay. Absence of FIR. Okay. No FIR was made itself is not a ground. As I said, there are some cases that PP can charge a person even without what we call the FIR. But normally there will be FIR lah. Okay, it depends lah. Okay, so not much of a big issue nowadays lah. Okay. So accused rights to FIR. Okay, initially we have this sort of cases whereby Anthony Gomez against Ketua Police Kuantan said that the picket has a right to inspect the FIR. Okay, but subsequently we also have cases saying that actually PP has no right to give the FIR to the accused. But then this is no longer the position of the law now, because we have Section 51A CPC, whereby the disclosure of the documents is one of the process to ensure. You see, because this one I think I'll explain later on. Eh, why is it so? Okay. Alamak. Okay, we have reports which do not amount to FIR. FIR itself, as I have told you, is so-called a police report. Sometimes we have a laporan tangkapan, arrest report. This itself is not what we call FIR, and you cannot use this laporan tangkapan under your section 108A, whereby you just need to get the uh, OCPD to top sign, certify as true copy. Then you can admit this as a evidence in court. You cannot do so because FIR, even though it is not a substantive evidence, but it is still a corroborative, supportive evidence. Therefore, the PP will use it to against the accused. But this is not applicable to your uh, arrest report because arrest report itself is not a FIR. Okay. And investigation diaries also, you cannot take it as is it like FIR? Okay, there are distinctions. So FIR usually in the context of police case, it refers to apa nama? Police report. Okay, very important, eh? And if you have a report whereby it is obtained from other police officer, okay, this one also very important. It does not amount to FIR. I will have a sample to show to you what does it mean by this. Because FIR eventually will be tendered and be marked as exhibit in the court. Okay. So anyhow, the court will need to give weight, regardless how high or low is it, it is still a piece of evidence, okay, to go against the accused. And this one, I already told you, it must be reduced into right and withdrawal of fire. Usually, this one is the we call the settle the lah. Like for example, if the crime itself is um not so grave in nature, it's just slapping on the face, just mouth punching the section 323 case, okay, Gado case or whatsoever. Sometimes they can achieve a reconciliation between the parties, okay, and the complainant can withdraw the police report, tarik balik police report. It can be done, but but having said so, PP will still have the power to decide whether or not to withdraw the charges against the accused. This is one key point here, lah. Yes, the complainant already withdraw the complaint, but the crime has been committed. You must seek the distinction. Tarik balik case tidak bermakna tiada jenayah telah berlaku tau. So, the PP, if let's say they already collected the what we call the medical reports, they found there's a case to charge the accused, it is up to them whether to proceed with the charge or not. But commonly, if let's say, how to say, if let's say the complainant themselves withdraw the case now, it will be a favorable point for the accused. Why I say so? Because the complainant probably will not be so cooperative when he or she is giving testimony during trial. He will say, he will not lie, but he will say, saya tak boleh ingat sama ada uh, Katie, orang kena tuduh pukul saya atau tidak. That is done lah. I mean, PP has no case lah. Okay, you get what I mean, eh? Tak boleh ingat lah. Usually they will say. Okay, report of on the status of investigation. Okay, those complainant, this one is also one of the practical rules that probably as a legal practitioner you should remember this. As a complainant or the one or the informant of a police report, actually you have the right to request what is the status of your investigation from the police. Okay, so you can do it not later than 2 weeks. Okay, that means to say, you can actually request from the police whatsoever status of the investigation report. Okay, I give you one example here. Okay, okay. This is the keputusan report police that you can actually, because you lodge a police report. Take for example, this my client here. He lodged a police report suspected to be there's a fraud case lah. He got cheated with some money by his own friend. But after like 1 2 months, he lodged the police report, but he is still seeing his friend, chatting in the kopitiam like nothing happened to him. So, like, as in police did not do any investigation or any arrest on the friend that suspected to cheat his money. So he go and on behalf of him, we go and ask for what is the status. Okay, so this is provided under your um, 107A of the rule. You can actually request for one status report. Okay. Yeah. Okay. Okay. Another one slide that one more section I need you to understand is whenever the police receive the so-called the report from the complainant or the informant, they will categorize the crime into non-seizable case or seizable case. Non-seizable case usually are referring to those light crime that carries punishment less than 3 years imprisonment, whereby seizable case are referred to those heavier crimes that is more than 3 years of imprisonment. Okay, so usually the police officer will seek a distinction first, If it is non-seizable case, for example, forgery, itu tipu tanda tangan, Okay, take for example, they will not have the right to investigate. Okay, this is your section 108. Okay, very important, Okay, if it is non-seizable case, they cannot investigate without the order to investigate OTI from the public prosecutor. Bear in mind, okay? And if they get the what we call the uh, order from the public prosecutor, the sergeant usually CPC to initiate what we call investigation, regardless if it's a seizable or non-seizable case, it must be sergeant, the three palang, the tiga palang fellow and above. Okay, sergeant, major sergeant, inspector, like that, above. Okay, they can only investigate in such a case. If let's say they do not want to investigate, under this section 1081 CPC, they must refer this case to magistrate. Okay, that means to say, okay, Balai Police think that this my client's punya case do not have so-called what we call heavy crimes element, the evidence provided not sufficient, then they have to initiate a private prosecution. That means to say they must refer to magistrate, and then the magistrate will need to take cognizance of this case and then call the offender to come confront each other. But in reality, I have not seen any of this private prosecution happen in magistrate court yet. Huh? Okay. So this is just, I think it's just by what we call um theoretically lah, theoretical. Okay. So admission of certified copy of information as evidence. This one I think I talked to you before. This is pursuant to your section 108 here, 108A. Okay. Because FIR, TP wanted to tender to the court. Okay, as one of the corroborative evidence. Corroborative evidence means to support your material witness punya statement. Okay, so they need to let this copy to go in as a bit. Okay, so this is what I mean by certified true copy, because eventually all the documents shall be subjected to documentary hearsay rule. Okay. Eventually, the opposing counsel or the defense counsel will dispute on the authenticity issue. That means to say this report itself probably is not a real one, it's a fake one. So because the what we call the maker is not here. So how to tender? In such a case, we have to rely on public document rule. And one of the public document rule is it must be certified by government servant that is categorized under the professional group. That means to say they are 41 grade, like M41, UD41, DG41, and above. Okay, professional group. But if you want to tender this FIR as uh, an evidence in the court, the so-called OCPD, the Ketua Police of this particular IPD, or the Ketua Polis Daerah, for example, this one is the Sri Alam one, must certify and sign. Okay. Otherwise, it will be subjected to dispute later lah. Okay. Can lawyer cannot certify? Cannot. Okay. Lawyer definitely cannot certify, because usually FIR is tendered by PP, not by the defense counsel one. Okay. And okay, I told you before, some of the police report is made for tujuan dalaman, internal usage of PDRM. I told you, if the police report is made in MOA, the JB one will have access to the same information. So sometimes it will be made by police. Okay, police, to state what is the case that they have taken down. So this is for their internal circulation, and it is not for the use as evidence in the court. So this is one of the exception I want you to bear in mind for FIR. So that means to say, yes, this is a police report, but somehow or other, it is not, it is made by police officer for their internal usage. So not for the purpose to tender it as evidence. Okay, just bear that in mind and understand how the law works. Okay, you have just now we talked about section 108. So this is the police approach towards non-seizable case, whereby in seizable case, the relevant section is 109. Okay, again, this is sergeant. The IO investigating officer usually, not usually, all the time must be sergeant and above. Okay, sergeant and above. So the police officer, sergeant and above, can actually investigate the crime without the need to get order from PP for any seizable case. Because seizable case, you must know, usually it is heavier in nature. Okay? Kesalahan yang lebih berat. Okay. So they can automatically investigate without PP. Okay. So what the police should do when they receive the information, somebody, for example, lodged a complaint in the police station, said that my wife died at home, probably due to murder, lah, suspected murder. So what police must do? They must come, they cannot just goyang kaki or chit chat in the office without coming to the crime scene. Cannot, they must proceed, they must proceed in person or ask one of his subordinate officer to proceed to the spot. You see, to to inquire into the facts and circumstances. Take, for example, my house now is the crime scene. So the police will drive their car and then new like that to come to my house to investigate and make necessary discovery. Ambil gambar lah, check whether there's where's the murderous traces lah, any other blood stain, take for example, this kind of thing. They must come, So this is the attitude, I mean the approach of the police towards a seizable offenses. Okay. So what are the situation that so in conclusion, police kena datang lah. Okay. So are the condition that police tak payah datang. Okay, so this is provided under your section 110, subrule 1, subrule A, whereby the crime is not serious in nature, so police need not to come. Okay, kesalahan ringan. Okay, or they think there is no sufficient ground for the proceeding, or they think, for example, they receive the information from somebody that is of unsoundness of mind. Cakap pun tak betul. Macam orang berapa, dia punya sakit mental, for example. So, how to believe? Every time the police see this mental person already made so much of police report here, every time goes, is it's a lie like that. So no sufficient ground for the proceeding. He cannot. He is not required to come. Okay, but somehow or other you must state the reason why you are not going. Okay, kenapa tak pergi perlu direkodkan. So these are all the important point for the purpose of examination. It will make your answer stands out a bit. Okay. And section 111 provided the police power to require the attendance of witness. Okay. Take for example, we have okay, I relate back to the jenayah sexual kanak-kanak case. Okay. For example, the witness, the victim, the complainant that lodged the police report. I use back the example that I've given to you lah. Okay, when she was 15 years old, she was being raped by the stepfather, being molested by the stepfather, and then actually during that time, he told her cousins about this story. Okay, but she lodged the police report when she reached 19 years old. So the police can actually ask the cousins who have prior knowledge in regards to this rape, because later on you need to corroborate, you need to make the credit of the victim inside the court better, isn't it? Otherwise, the defense counsel will say, why you make the police report now? Your evidence could not be trusted. This is not a contemporary evidence. This is an afterthought because you quarrel with your stepfather, then you lodge a police report. You purposely want to frame the accused, take for example. So you have some other witness that actually listen to her part of the story that time. So the police can actually ask them to give rakaman percakapan in police station. Okay. If any person refuse to give, for example, you receive WhatsApp message from one Sergeant Ahmad required your assistance to give this Section 112 statement in the police station. Uh, Already many times it text you lah. Every time you just say you go, but you refuse to go. You didn't go. The police actually has the right to report you to the magistrate. The magistrate can actually issue a warrant tangkap, to secure your attendance. Okay, even though you are not, you just want to stay out of trouble. For example, you are the witness, you just want to stay out of trouble and pretend this matter has no any relation or concern to you. Okay, because you kiasi, isn't it? I mean, you takut mati sikit lah. So you don't want to offend anyone, but you can be subjected and you can be compelled to go to police station. Okay. And one more thing here is if let's say, for example, if you do not go, you do not cooperate with police, you might be subjected to Section 174 of Penal Code. Okay, we'll look at it later. You see, this is Section 174 of Penal Code. For example, if you are being called to police station, you are being given the dates many times already, but you don't compel. You might be liable to imprisonment of 1 month or with fine or both. Okay, so this is police station. If you do not go for court proceeding, okay, proceeding with a subpoena, probably you are also liable, if under the said section 174 penal code, even worse if the court proceeding one is 6 months and 2,005 ringgit or both. Okay. So you must know how to advise your client. You cannot say just pretend you never read the message and then suddenly your client received one warrant tangkap by police for not cooperating with the police. Okay. Nowadays, I just need to make known to you this case Utaya Kuma anak lelaki Punusami is no longer applicable, whereby last time when the police require the attendance of the witness to give what we call statement inside the police station, by right they should serve a letter to them in person. But somehow or other, the new section, this apa nama, the section 3 is already deleted by the amendment. Nowadays, we do not need services. Normally WhatsApp or a call will do. That means to say, next time if you have any client that receive call from police station, provided it is a genuine police officer, you must ask he or she to attend to the police station to give witness at his convenience lah. Okay, at his convenience. Okay. This one is the warrant tangkap lah. If you do not, this is not the exact one. This is the section 39A one, but it looks similar lah. So this is the warrant to secure the witness attendance. Usually, the police will do it for those type of witness that is very important, material witness, but very stubborn type. Panggil 10 kali pun tak mau datang. I have no choice but to catch you lah, to take action against you. Okay. So later on, we need to look at section 112. Section 112 it is rakaman percakapan. This is witness statement lah. Examination of witnesses by police. Okay. You must understand this section 112 in great detail because you will see this question repeated in your evidence paper. Okay. There are a few provisions whereby, okay, section 112 sub rule 1 said that Okay, during the police investigation, the police may examine a witness orally or any person, okay, and in regards to all the facts and circumstances of the case, and shall be reduced in writing. Again, the word is shall be reduced in writing. So that's why this is a form of documentary evidence. And Section 112, Rule 2 said that the person shall be bound to answer all questions. Okay, that means this is coming in a usually yes soalan dengan jawapan. So whenever the police you a question, he will type lah. He will have prepared the question already lah. You need to answer accordingly. Okay, unless those answers, okay, is the one that might expose him into criminal charge, penalty, or forfeiture. That means to say, the police, supposing you are the eyewitness of a robbery that taken place. The police ask you some question. Eh, you ada ni tak? You ada buat sekali tak jenayah tu? You ada rompak sekali kan? Something like that. Then this sort of answer, if it is a yes, probably can expose you as a witness towards criminal charges, isn't it? You are the co-accused lah. Later on, the police will charge you. So you are not bound to answer. Okay. And the third rule is you must state the truth. Okay. You must state the truth. Okay. And the police will usually inform the criteria of this the must answer all question, and you can only not answer if the answer shall incriminate you. Okay, we'll see the example later. And subsection 5, the statement after it is being reduced into writing usually shall be signed by the person, and also take for example the person cannot sign, give a thumbprint. Usually police nowadays very smart lah. They look at your signature is one kind. That means to say it's just an initial lah. It's not a complicated, and it's easily forged signature. They will just ask you to thumbprint the statement just in case you go back to your statement, because FIR sometimes you can use to impeach witness, by PP, not by the accused lah, because some witness they got bribed. Okay, after the incident, if yes they are the material witness, and then the accused know him, the accused sahut some money to him so that he bohong lah in the court. So nowadays the police also very smart. It shall require sign and also thumbprint by the witness, and the police what we call the section 112 statement shall be read to the witness in the language that he understood, and he shall be allowed to make any changes, correction, or any pindaan amendment as he wish. Okay, so I give you one example here to have a look to understand what does it mean by all the proviso under your section 112 in a better manner. Because when you see it, you can understand. Okay, so first and foremost is of course this is percakapan dalam pemeriksaan, or it depends lah. Sometimes they will put it as a title rakaman percakapan. It depends on the police station that record the statement. Okay, so the detail who give, okay, done by inspector or sergeant. Okay, so and you see this or not? Section 112 CPC. Okay, the ceraian 2 and 3, bahawa kamu dikehendaki untuk menjawab semua soalan yang ditujukan kepada kamu berkaitan dengan kes yang berkenaan bila disoal. So answer all question. Kamu boleh menolak daripada menjawab mana-mana soalan dengan syarat jika jawapan yang diberikan nanti boleh menyebabkan kamu menghadap satu tuduhan jenayah atau penalti atau perlucut hakikat. That means to say loss of one property lah. Okay. And uh, third is what? Bahawa kamu dikendaki memberi keterangan yang betul. Must state the truth. Tidak kira sama ada percakapan itu dibuat dengan sepenuhnya atau sebahagian. Full or in part. Daripadanya bila menjawab soalan-soalan tersebut. So police nowadays also very smart. They will warn you and they will check with you in their first question. Sama ada awak faham ke tidak yang ni. Okay? So first answer usually is already pre-typed lah. Ya, saya faham. Then they will continue. You see the thumbprint here, no? And also the sign. This is to avoid the witness suddenly said that I never signed this. I don't even know this apa nama this section 112 statement exists. I tak tahu. They cannot say like that. Okay. And then they will warn the witness. Adakah kamu tahu bahawa memalsukan keterangan adalah satu kesalahan? This one also is a standard format nowadays. Ya, saya tahu. And adakah kamu ingin membuat sebarang penambahan atau pindaan dalam percakapan kamu ini? Tidak. Okay, so they are giving the opportunity of this witness to make changes, alterations, correction whatsoever with these the content of the witness statement. Okay, and last but not least, percakapan dibacakan balik kepada pengadu dan difahami, seterusnya menurunkan tanda tangannya. So, police know the law very well. Okay, so you must also know the position of apa nama section 112. Okay. Sorry to say, but Jaya Raman is an old case. How to say? Usually, Section 112 now, because no black and white. One case happened, take for example, a murder happens. Now, today, the case probably will be ongoing to 2 years from now, 2024 case, trial 2026. So anything could be forgotten by the witness. So witness statement is one of the so-called contemporary evidence. The evidence that is fresh, that is immediately after the incident, that the chance of fabrication or the concoction is very low. So this is something very credible. Usually it is reduced in writing. But somehow or other, we have some old case law say that you no need to reduce. But I beg to differ. Section 112, letters amendment shall be reduced in writing. Okay. And one more important ground rule is section 112 is not a stand-alone provision. It must be read together with your section 113. Okay. We will go into the discussion of section 113 later on. Okay. So this is just some case law to explain how this section 112 is being taken down. I will really suggest you to look at this lah. Then you understand, oh, this is a soalan jawapan. This format is there already, It actually provides you a more better illustration and imagination when you are approaching, rather than you just read some dull text and then tomorrow you forgot. No point one, When you look at this rakaman percakapan in real, then you have a clearer understanding, because CPC same apply to your these rules of court. They are all procedural rules. Everything has been put into practice. whatever contained inside this CPC, this is how the court, how the police should follow in their SOP. So when you look at this, it's already a complete description for you to understand section 112. Okay, try to understand these better than your just memorizing the law. Okay, memorizing the law itself is very painful. Okay, and okay, apa? Form of question and answer. PP against Subramaniam. All very old case. Okay, so statement shall, whenever possible, be taken down in writing. Okay, that means to say, whenever possible. Okay, whenever possible, is actually refer to thumbprint. Okay, thumbprint. Okay, if you look at your section 1, 2, sub rule 1, actually the statement itself must be reduced in writing. Okay, but the signature part, because the word whenever possible, so that means to say not a mandatory requirement, but somehow or rather, if the police want to achieve their good KPI and they do not want to take the complaints from PP, because PP is the one that will use the evidence in the court later on. So they also don't want to get scolding from PP saying that, oi, you tengoklah apa you punya kerja ni. Masa you rakam percakapan you tak ada sign, tak ada chop. Sekarang witness cakap benda lain di court. So how you want to answer? So nowadays, usually they will ask you to sign. All the case I've seen, they will use sign and print, and sometimes both together. Okay. So failure to have signature or thumbprint, probably the statement itself is not admissible. Okay. Abdugani Juso against PP. Okay. In this CLP examination per se, the section inside your CPC, your rules of court are more important than case law. Do not get the other way around. Write the correct section supported by case law. So this is the approach in your exam. And section 112 shall be recorded voluntarily. Okay, voluntarily, and you cannot force a witness with violence, inducement, threat, or the promise. The ITP also cannot. It must come out from his own willingness. Okay. So alteration and amendment, I already told you inside the sample that I've given to you, the last paragraph there, it already shown kamu ada apa pindaan or any correction you can make. Okay. So whether an accused person is entitled to statement of weakness under section 112. That means to say, shall we provide section 112 statement to the accused during the disclosure procedure? Okay, we have all case saying that, saying that there's no obligation to supply the accused statement recorded from potential weaknesses. Okay, take for example, if let's say I have a drug case and the person that lodged a police report or even giving this section 112 statement is a protected witness, is an informer, then the police will withhold this information, the details of this section 112 statement from the accused, because after that, if let's say this is a drug syndicate, you only catch a few accusers, you only catch a few offenders, criminals. Okay, but the big boss are still on the run. Okay, so you do not want the whole intel to be leaked out, isn't it? So some case law actually said that there's no obligation to supply the accused with this sort of section 112 statement. And this is also provided in your case of Husti against PP, said that the police statement is absolutely privileged. Okay, so that means to say this is protected. Okay, boleh tengok. Okay, and but recently we have cases like this new enactment, Section 51A, whereby PP will we try as far as possible to ensure the justice has been carried out fairly and justly in the court process. So you see, the bargaining power between the prosecution and also the accused are always not balanced. Having said so, the prosecution will have more accesses towards the resources. They have more money, they can investigate all that. So actually, this Section 51A CPC required public prosecutor, PP, to provide the accused one set of documents, whatever they have found, if it is not protected, like some, the privileged documents like OSA, the Laporan Tangkapan, Diary of Investigation, those are not relevant, and also actually they are protected also lah, documents. You have to provide other relevant material documents to the accused. Okay, PP will have to voluntarily give the accused and also his counsels all the relevant documents in regards to their investigation. So this is to help the accused to prepare their defense. Okay, so after having this Section 51A, sometimes the rakaman percakapan will be given. Okay, take for example, this is the Senarai document uh, under Section 51A CPC that is provided by PP to one of my accused client. Okay, so it is 23 lists, inclusive of one Brakapan percakapan from OKT himself. You can see, there's no, of course lah, there are some other witness punya rakaman percakapan, but PP is withholding it. It's privileged, so they did not provide. But the rakaman percakapan OKT, because when we interview the client will say that time the police arrested me. I was very panicked. Actually, I do not remember. This is more often than not, it's truth. I do not remember what I said. What I have signed also, I don't remember. So PP will give you one rakaman percakapan before the trial is ongoing. This of course includes the relevant information like the Jabatan Kimia punya laporan. There's a search list, itu apa? Borang Geleda is whatever they found, they asked the accused on the spot to sign one. And also the gambar raja kejadian, tempat kejadian, and whatever goods, drugs, murder weapon, they have taken photo on the spot, they'll give to you. Okay, so this is under your Section 51A of CPC. Like I say, if you have the resource or you have any friends that is doing litigation, criminal litigation, try to ask for this sort of documents for you to appreciate the CPC or rules of court better. It will be extremely helpful for you. Uh, okay, where will we? So subsection 4, the provision of Section 112 compel the police to give warning to the witness, whereby they can have the right to refuse to answer certain questions that subject them to criminal charge pertuduhan, penalty, or lucut hak lah, some lucut hak. Okay, towards the property. Okay, so this is the warning that must be done by the police during taking down the witness statement. Okay, and as I've told you, Section 112 itself is not a standalone provision. it shall be read together with your section 112. 113, sorry. So section 113 said that no statement made by any person to police officer in the course of police investigation under this chapter shall be used as evidence. Okay. So you try to understand this statement, this thing here. Okay. The whole statement, it is deemed to be privileged. You cannot use this rakaman percakapan inside the court without calling the material witness. So this is what it is supposed to mean as an overall punya apa nama overall impression of the uh, criminal process. Okay, because somehow or other, if you have this sort of statement to be admissible, probably the state, the police themselves will abuse their power and force and compel a witness to give some evidence in favor of their case. So nowadays, based on this, the new amendment and all that, only subjected to certain criteria, then section 112 statement that is signed, thumbprint by the witness shall be admitted in the court. Okay, so this is subjected to the condition whereby you want to impeach the credit of the witness. Okay, because like I've told you the story, the eyewitness of the murder, take for example, when he was doing the section 112 statement, now he said he saw me and then he saw me murder my wife and all that. But after 2 years, he got bribed by my family member lah, because I want to weaken the prosecution's case. So I bribed him. Okay, he's going to say something I didn't see. There is a very material discrepancy from his new statement, new testimony in the court, uh, as compared to his previous section 112 statement. So the DPP got stunned during that time. So the DPP called that witness actually to support his case, but somehow or other, this witness turned hostile. You get what I'm trying to say? Okay, so DPP can use the previous section 112 statement that he made in the station to impeach his credit. That means to say, yes, now I'm DPP in the court. So I call a witness, suddenly that turn and twist the story, suddenly create the reasonable doubt to the accused. So what I have to do, I have to erase his evidence as a whole, totality. What? So what evidence I have to impeach his credit? I have to compare. I have to ask the court, look, court, Arif Hakim lah. This material discrepancy. What he say now is totally different with this section 112 statement that he had made. 2 years ago probably. Sama langsung. Okay, material discrepancy. So saya mau impeach credit witness ini. That means to say I want to remove this witness in totality. Okay, and have all his the evidence, whatever he state lah, cannot be taken into consideration, impunged by the court. Okay, important. So this is one of the exception that can use section 112 statement in the court. Okay, and section 113 subrule 3 said that the accused can use his statement, his 112 statement, to support his defense. Okay. Whatever that section 112 statement given by other witnesses, that's why you have to appreciate the rule better. Okay. Section 112 statement made by witnesses other than accused tak boleh digunakan kecuali untuk tujuan impeachment. Okay. But the accused made section 112 statement, like my client, the drug case, he did have the rakaman percakapan on the spot, and all that. He wrote down whatever jawapan lah that police asked him during that material time. If I when I look back his statement, because it's given to me, if I found a statement that is probably favorable to me, I can use it to support my defense. For example, my client was not actually present in the premise where the drugs was found. He was in the car during the arrest. So he put that statement in the section 112 statement. He signed already. So I can use, yes, he's telling the truth. Why I say so? Because the arrest police record his statement, it is shown that he was inside the car rather than the premise where the drugs were being found. Therefore, there's no custody, control, and possession of him towards the said drugs. He's not liable to drug trafficking, for example. Okay, so you must know how to use this exception to the exception, exception to the exception. Okay, and section 113 subrule 4 further provides that, okay, this section, nothing in this section shall be deemed to apply to ID parent, okay, this kawat cham punya statement is not applicable, it's not considered as section 112 statement at all. Or in regards to your section 27, section 31, 32 subrule 1 subrule A, 32 subrule 1 subrule I, and 32 subrule 1 subrule J of your Evidence Act 1950. Okay, that is your dying declaration when the police officer is discharging the duty. Okay, this is all hearsay punya exception lah. And also this section 27 is whatever statement that you made or the witness made that is incriminating himself when leading to the discovery of one probably murder weapon or something like that. This statement is for can be used to support the evidence as a corroborative evidence. Okay. So these are all usable one, okay. I repeat myself again, section 112 statement by the witness is privileged, cannot tender as a piece of evidence in the court. But the witness, if they are material that are important, shall be called by DPP or PP, okay, to give oral evidence in the court. But there are exceptions whereby section 112 can be admitted. Subsection 3 said that accused can use his own rakaman percakapan untuk menyokong defense. Okay, pembelaan dia. And also ID parent, section 27, section 32, subrule 1, subrule A, IJ of Evidence Act. Those are the exceptions. And one more thing is very important, section 113, subrule 5, whereby if you are being charged to make false police report, then your section 112 statement is a material evidence to form the ingredient of this charge, isn't it? Because you memalsukan itu rakaman percakapan, you lie in front of the police. Subsequently, you being caught and being charged. So your whole section 112 statement shall be admitted in this particular event. Okay, if you get charged and you get caught for lying. Okay. Mm. So exception to section 113, Kawat Cham, ID Peret, section 27, 31, 32, subrule 1, subrule A, okay, section 32, subrule 1, subrule I, and section 32, subrule 1, subrule J. Okay, please try to understand this, because if you do not read the law in great detail, probably the examiner will trick you whether this sort of statement is admissible or not. So this is pertama, this one of the laporan kawat cam. This is not deemed to be section 112 statement. So this is not privileged under your section 113. Okay. Kawat cam usually is to identify lah, who is the criminal. Usually in those uh, apa, case rompak lah, snatch thief lah, okay, or sexual perpetrator, okay, all these sort of case that require the identity of the offender or the accused to be determined. So they will do lah kawat cam. And if you have a specific laws, you have to be a little bit careful. Having said this section 112 itself is absolutely privileged, but somehow or rather, in drug cases, you have your exception under your section 37 B subrule 1 subrule B. Okay, this is what we call as Miranda warning. Not sure whether you heard it before. Okay, if you watch a lot of this US movie, they'll warn you with a caution statement. Whatever you said, you can remain silent, but whatever you said shall be tendered as evidence. This is something like that. Okay, so in Malaysia we have this sort of caution statement, but it is in Malay. Adalah kewajipan saya memberi amaran kepada kamu bahawa kamu tidak diwajibkan berkata apa-apa jua atau menjawab apa-apa soalan, tetapi apa-apa jua kamu katakan sama ada sebagai jawapan sesuatu soalan atau tidak, boleh diberikan sebagai keterangan. So this is one specific provision under section 37B subrule 1 subrule B of your Dangerous Drug Act 1952. So apa-apa incriminating kat sini, habislah. You see? He kept the drugs lah, he sell the drugs on behalf of one person, take for example, okay, all against him, but can be admitted in the court. So difficult for our defense later. So what are the specific laws when you are doing criminal paper that you should bear in mind? Is number one, DBA, the Dangerous Drug Act. Number two, MACC Act, the corruption one. AMLA also, money laundering one. The Child Act, and also the Sexual Offense Against Children Act. These are the very specific laws that probably will have uh, governing provisions for the admissibility of certain evidence, and it also governs some sort of procedural rules, because CPC is a general one. But somehow or other, if let's say the accused was charged under this sort of specific act, you have to rely on your knowledge in regards to this sort of specific law. Okay, these are the areas that you may need to put attention. Okay, so you want to know a little bit of history of section 112 prior to the amendment. Okay, the statement made by witness may be admissible against him. Okay, if he becomes the accused later on. In case of PP Haji Harun. Okay, but somehow or other now the law has changed lah. Otherwise, the rationale behind that is to protect the public from the oppression by the what we call the authority. Because Malaysia, unlike UK, we do accept illegally obtained evidence. I repeat, Malaysia accept illegally obtained evidence. There's no rule saying that even your evidence act, I forgot 1-4 something, does provide that you can accept the illegally obtained evidence. So with the latest amendment, the police cannot force, cannot compel, cannot, punch the witness or lock up the witness, long time, drag the time, so that he can sign a favorable witness statement for their case. Okay. And you must remember the section that I have told you, whereby if it is in if it is to support accused case, yes, it is admissible. If it is to impeach the credibility of the witness later, it is admissible. And if it is to this is just repeat, if it is to talk about this ID period, can. Section 27, the facts leading to discovery, can. Section 32, subrule 1, subrule A, the dying declaration 1, can. Okay. And section 32, subrule 1, subrule I and J, the discharge of police duty in the course of investigation 1, can. You can use this section 112. And last but not least, if you are being charged for giving false statement under CPC, so section 112 statement can be used as one of the important material evidence. Okay. Okay, I think